This week on Q&A, a new biography of Supreme Court Justice Louis Brandeis. The author is Melvin Urofsky.
Melvin Urofsky, can you remember when you first thought you might like Louis Brandeis?
In fact, it's a memory that's well seared into my consciousness. I was a graduate student at Columbia in the early 60s, and the great biographer of Woodrow Wilson, Arthur Link, had written in one of his books that Louis Brandeis was the intellectual architect of the new freedom. And I glommed onto that sentence, and I went to my mentor, Bill Luchtenberg, and I said, I think there might be a doctoral dissertation here. And Luchtenberg said, I think so too. So I did all the paperwork, researched Brandise a little bit, got it approved, and then in the fall of 1964, I moved to Columbus, Ohio for my first teaching job at Ohio State. A few months later, I went down to Louisville where the Brandeis papers are. And there I made two discoveries. The first one was there wasn't enough information on that particular topic to support a dissertation, but the Brandeis letters were a gold mine of information. So David Levy, who was a colleague of mine at Ohio State, and I began work to get the permissions to edit the Brandeis letters. And as my wife says, Louis has been living with us ever since. So,
how did you get permission, and from whom?
Well, the papers are in the possession of the University of Louisville Law Library. And as it turns out, the dean of the library knew a member of the Brandise family who knew one of our senior professors at Ohio State, Mary Young. They'd gone to college together. So after a series of phone calls to say, are these people okay, we got the permission. The following summer, we were interviewed by Brandeis's daughters, who then gave their blessing for us to go ahead. And then we started what ultimately would be 7 volumes of letters, and on my part, some other books that were related to Brandeis, plus a midlife crisis trip to law school.
Midlife crisis? What year?
I was 40. It would have been 1979. I got contact lenses, which I still wear. I bought a sports car, which my son totaled, and I went to law school.
Why?
Brandeis. I had discovered that in editing the letters, while he was a justice, some of the cases we really hadn't done properly. They weren't wrong, but they didn't, a case like Erie, which is extremely complex, we hadn't done justice to it, no pun intended. And I'd become fascinated by the law. I didn't want to practice, but I wanted to study, so I went to law school, had a wonderful time because I wasn't looking for a job, I wasn't looking to make law review. My grades were decent, they weren't spectacular. I may have been the only person in law school at that time who really enjoyed himself.
Where did you go to law school?
University of Virginia.
So you taught most of your life, though?
I've taught all my life.
And where?
My first full-time teaching job was at Ohio State. Then I went to State University of New York at Albany, and then the bulk of my teaching career was at Virginia Commonwealth down in Richmond, Virginia. I'm now a visiting professor of history at American University here.
What's the thing that you like about Louis Brandeis the most?
His integrity. And the fact that, as I tried to explain in the book, he was an idealist who was also a pragmatist. He didn't have his head in the sky and some notion of a grand scheme. He was very much grounded in the reality. This is where we live. This is what's wrong. This is how we have to try and make it better. He once told somebody, don't believe in isms. They never work.
He was born in 1856 and died
in 1941.
Was on the court for what years?
1916 to 1939.
He was born in Louisville. Where
Yes.
did he live most of his life?
Well, he lived in Louisville till 1873. Then his father, sensing the great panic that was coming, closed down his business and took the family to Europe for 3 years to visit relatives and to teach their children about their lives there. When Brandise came back, he entered Harvard Law School. And after he graduated Harvard, except for 1 year in St. Louis, he practiced law in Boston until his appointment to the court in 1916. Then he lived in Washington the rest of his life with a summer home on Cape Cod.
Did he actually get an undergraduate degree anywhere?
No. He didn't, and you didn't need an undergraduate degree to get into Harvard Law in those days. He did go to a German gymnasium for a while, and at that time the gymnasium would have been a cross somewhere in between high school and college. So he got some post-high school training, if you will, but he never had a BA.
How many of I know he had two daughters, Susan and Elizabeth. Did you meet either one of them?
I did. I met them in the 1960s. We went up to Cape Cod to the summer home, which is still in the family. And we met Susan and Elizabeth. Susan's husband was already dead at that time, but we met E.B.'s husband. Elizabeth was always known as E.B. And at that point, my favorite story is we're sitting outside on an August afternoon on Cape Cod, and mosquitoes are eating us alive, but they didn't dare come near her. And she was just totally oblivious of them. She was quite a character. They both were. Both daughters made quite good records for themselves. One is a lawyer, one is an economist.
There's a lot you can talk about, obviously. You've got a huge biography of him. But one of the things that got my attention in the book had nothing to do with the law. It had something to do with something called the salons that he used to have. Something you don't see much of anymore. Explain what those were and where did they happen and all that.
Brandise, from the time he and Alice were married, and he had a place of his own where he could invite people, was always inviting people who came to town, reporters, politicians, reformers, to come have dinner with him. When they moved to Washington, he and Alice had a Monday afternoon tea. And they would invite young people who worked in the government, other members of the court, reporters going through town, people from Louisville whom happened to be coming through, professors from Harvard were always welcome. During the New Deal, this became a very important place to go to. Many of the young New Dealers who had come to Washington to work for the Roosevelt administration had been sent there, some of them by Felix Frankfurter, would come to Brandise, and he would question them on what they were doing, why were they doing this, what problems were they facing. And it wasn't so much they said, well, you ought to do this or you ought to do that, but I interviewed some of them later on. They said we would talk to him and he would ask us questions, and when we were finished, we understood something, a problem that had been bothering us would go away. I can give you one example of this. There was a woman who was heading a branch, the theater branch of the Works Project Administration. And she had this problem. Under the law, they could not pay royalties to the authors of plays, and she felt this was unfair. And so she goes, her husband had been a classmate of one of Brandeis's clerks at Harvard. So she goes to the Monday afternoon tea, and Brandeis is quizzing her, and she says, Mr. Justice, I have a problem. And he says, what's the problem? And she explains she can't pay royalties, and he thinks for a minute, he says, rent the plays, which was the ideal solution, because that way they could pay the authors. It wasn't royalties, because it wasn't based on the number of performances or anything like that. They would just pay a weekly rental, and it was fair to everybody concerned. And he apparently did that hundreds, thousands of times.
Were there many accountings that you could find about those salons?
Oh, yes.
Who wrote them down and who talked about
Well, the clerks were always pressed into service to help serve tea and to make sure that no one monopolized Brandeis's time. Alice kept a very close eye, and when she thought that one person had had enough time, she would tap the clerk, send them over with the next person to introduce. And the clerks in their reminiscences have spoken about this a great deal. And a number of other people in their autobiographies. William O. Douglas, for instance, writes about going there. And he was a great fan of Brandise, and Brandise thought, he called him a hell of a fella.
You say that that Alice Brandise only served tea and
Cookies.
Ginger snaps.
Yes.
That's all.
That's
Nothing
all.
else.
That's all. They were not cheap in the sense they were aesthetic. And as he got older, he grew more aesthetic. And Judge Julian Mack, who was a gourmet, used to say that if you ate at Brandise, you had to eat twice, once when you went there and then afterwards to get a really good meal. One time, was it Dean Atchison or one of his clerks who had grown up on a farm was there for dinner, and they were passing the asparagus around, so he took a farm portion, not realizing that what was on the plate was all there was, so that by the time it got down to the end of the table, there wasn't asparagus for the remaining guests. He didn't make that mistake again.
Explain this. You say in the book that he told his wife that they were going to live well, but simply.
Yes. They bought at good stores in Boston. They bought good clothes and kept them. He was not a slave to fashion. After one of his suits wore out, he replaced it with essentially the same suit, usually from Filene's. They bought in good furniture stores. He once told his brother, "Don't buy any furniture that your grandchildren can't use." And they never owned a car. He finally had to give up his horse, and they made an arrangement with what was essentially a limousine service, or it was an individual driver who owned the big black Packard, that to come get him. He gave up his horse only when car traffic in Washington made it dangerous. But there's a picture in the book of him and Alice in a little one-horse buggy in 1921, so he was still using his horses. He was still riding late in life. He only owned one house, or two houses, I should say. He only bought the place on Cape Cod because the owner from whom he had rented for a number of years wanted to sell it. And Brandise liked it too much, and he didn't know if the new owner would rent to him, so he bought it. But otherwise, they didn't believe in owning things. Things had no appeal to him at all.
How much money did he make?
A lot. He was successful almost from the time that he and Sam Warren opened business in Boston. The best numbers I can give you, in the 1890s, when most lawyers in the country were making less than $5,000 a year, he was making over $50,000 every year. That would be the equivalent of about $900,000 today with no taxes. He was a millionaire by 1907. When he went on the court, he was worth $2 million. When he died, he was worth $3 million. During the Depression, his very conservative investments took the mildest of hits. And so he had the money. And he gave very generously to relatives, to causes he believed in, to Zionism, to other groups. But he said, once I have enough money that I can take care of my family, I want to do more and more public service. I don't want to be a slave to my law practice.
You say at one point in your book that he was a Republican, but he was a Democrat.
He was always a small d Democrat. He was in the Republican Party for a long time because the Democrats, when he was growing up, was the party of Romanism and rebellion, as it was once thing, of the party of the South. He was opposed to William Jennings Bryan, but he breaks with the Republican Party when Woodrow Wilson comes to run, and from that time on he is a member of the Democratic Party, at least till he goes on the court, but he was always a small d Democrat.
You say he was conservative but liberal.
He always described himself as conservative, and one of the paradoxes that I try to explore in the book is how a man who saw himself as conservative became a liberal icon. And part of it is that he appears liberal in comparison to some of the rock-bound reactionaries like McReynolds and Taft and Sutherland, with whom he served. He was a Burkean conservative who, like Theodore Roosevelt, with whom he had far more in common than either one of them probably would have admitted, who believed that if you wanted to keep the best of the past, you had to adapt it to current realities. And that was what the liberals fashioned on during his dissents in the 1920s, in which he is arguing that the court should exercise restraint, should allow legislatures to try to do what they're permitted to do. His opinions on privacy and free speech, this is what the liberals made of him.
I wrote down a number of things that you said about him, including, we've talked about never owned a car, but that he didn't belong to a synagogue, and yet he was very active in the Zionist movement.
There are two types of Zionism, if you will. One is religious Zionism, and the other is secular Zionism. He was always a secular Zionist.
Let me stop you.
Yeah.
We talk about this all the time, but define Zionism for someone who's never paid attention.
Zionism was a movement started by Theodor Herzl to return the Jews to a homeland in Palestine.
Where was Herzl at the time?
Herzl was a Viennese journalist who had who was a secular Jew, a non-practicing Jew, but he was a reporter at the Dreyfus trial in Paris. And that awakened his Jewish sensibilities. And in 1897, he writes Der Judenstaat, the Jewish state. And at first, he was willing to have this Jewish state any place until more religious Jews convinced him that the only place Jews would really be willing to go to would be back to Eretz Yisrael, to the land of the Bible. And Brandeis' uncle was a Zionist, although Brandise did not know it at the time. And he first becomes aware of Zionism in 1910 when a reporter, Jacob de Haas, interviews him. Brandise then studies and eventually comes to the conclusion that Zionism is the type of idealistic reform that he could support. Now, he never was religious. He says that his mother did not believe that anyone should be bound to any one religion. Rather, they should be aware of and sensitive to all religions and treat them all with respect. He never denied his Judaism. But considering that he was one of the most successful lawyers in Boston, he had very little to do with the Jewish community of Boston. He made donations to various Jewish charities, but they were, for the amount of money he had, nominal compared to some of the money he put into other reforms.
Tell us about the Dreyfus trial just for a moment.
Alfred Dreyfus was a captain in the French army, and there was a scandal in which it was determined that a spy had sold military secrets to the Germans, France's age-old enemies. And Dreyfus, although innocent, was blamed for it, and his main problem was not that he was a spy, but that he was about the only Jewish officer, and there was virulent anti-Semitism in France at that time. And a number of Zola-rights accused at that point, accusing the French of a mock trial, that it was a farce. And of course, the most important result that comes out of that is Herzl's book. Eventually, Dreyfus is exonerated, and the real culprits, who were French officers, were found.
This is somewhat of a non sequitur, but he later in his life got involved in the Sacco and Vanzetti case. And what was that, and how did Brandise get involved in it?
Okay. Sacco and Vanzetti were two Italian immigrants who were charged with a payroll robbery and murder in South Braintree, Massachusetts. Their trial was a farce. Evidence that might or might not have exonerated them was kept there. The judge was prejudiced. He kept referring to these anarchist bastards, practically ordered the jury to find them guilty. And after the trial, a number of people, most notably Felix Frankfurter, began this long and arduous task to show that the trial was not fair, there was no justice there, and trying to get a new trial for them. Frankfurter was a professor at Harvard Law at that time, and Brandise provided him with an annual stipend, which later aroused some eyebrows, raised some eyebrows, but was not either illegal or immoral at the time. Brandise was able to give, I have to digress a little bit here, Brandise was able to give so much of his time to reform work because he was rich. He made a lot of money as a lawyer. He had invested it soundly. He had a good return. Frankfurter was a professor at Harvard Law School at a time when the law schools did not pay the high salaries they do today. He had a wife who was often sick, so all of his salary was essentially going to support his family. What Brandise gave him was an annual stipend, which at first Frankfurter didn't want to take. But there were no strings attached to it. Essentially, he told Frankfurter, you are now doing reform work, it costs, and you should be free to take on whatever causes you want without having to worry whether they can afford your services or not. When Frankfurter became involved with Sacco and Vanzetti because of Elizabeth Glendower Evans, who was a close friend of Brandise and the Brandise family. And Brandise sent him some extra money to help defray the expenses, but perhaps more importantly, Brandise agreed that one of the houses he owned as a rental property could be used by the Vanzetti family because Mrs. Evans was very concerned that they had no place to stay where people were constantly pointing at them and reporters were showing up. So it was essentially became a safe house. And Brandise was aware of this. It also made him very unable later on to interfere in the case at all when lawyers came for a last-minute stay of execution.
So what happened in the end to Sacco and Vanzetti?
They were both executed. Subsequent research is still divided over whether they were guilty or not. There are some books who are quite sure that at least one of them was guilty, and others say both were, but it's still not clear.
Have you written much about Frankfurter?
I have read a great deal about him, and in fact I wrote a short biography of him as a justice.
What's the connection between the two? And you suggest in the book, I think you quote Brandise as saying that Frankfurter was a half-brother and a
half-brother, half-son.
Half-son.
They met when Frankfurter was still relatively young, and Brandise was already an established reformer, lawyer. They met at the House of Truth in Washington, which was a house that Frankfurter and a number of other single young men shared. Holmes would stop by, Brandise would stop by when he was in town. And Brandise took Frankfurter under his wing to some extent, helped to arrange a professorship at Harvard for him, and was the only person to whom he would talk freely and openly about events on the court. There's a wonderful series of notes that Frankfurter left of conversations he had with Brandise in which they would discuss court cases, personality. It's one of the few glimmers we really get into the inside of Brandise as to what he thought about his colleagues on the court. And after Brandise could no longer do the reform work that he had been doing, Frankfurter had already gotten involved to some extent. The problem was where Brandise could afford to take any case he wanted, any reform he wanted, because he was paying his own way, Frankfurter couldn't. Frankfurter just didn't have that cash, if you will, to be able to lay out, for instance, to have a brief printed and cost money. He didn't have that. And Brandise wanted to make sure he did. So from 1917 on until late 1930s, when Frankfurter himself went on the court, Brandise gave him what would average out to about $50,000 a year in terms of our money. It was much less then, but if you're talking about printing briefs, if you're talking about travel, if you're talking about hiring research assistants, none of it went into Frankfurter's pocket. Nor did Brandise ever tell Frankfurter, I want you to do X or I want you to do Y. It was always left to Frankfurter's discretion. And despite the scandal it sort of created when it became known about 15, 20 years ago, it was never a secret at that time. I spoke to some people, older professors at Harvard who had been there and knew Frankfurter and said, we all knew that he was getting help from Brandise on a number of things so he could do this. So it wasn't really a big secret.
He was almost 85 when he died in 1941. How much money did he have when he died?
His total estate was $3 million. After taxes, which were fairly heavy, and it still came out to $1.9 million.
On $41 or dollars today?
No, this is in $41. Today it would be quite a bit more. He had invested very conservatively. He said he didn't want to have to watch his investments. He had a woman who had come to him as a young girl in his law office in Boston. She had a head for numbers which he recognized. He soon put her in charge of office finances, and after he went on the court, she continued to handle his personal portfolio. And he paid her a fee for that every year.
There's one of your chapters where you talk about how he got involved. I don't remember if it was the New Haven Railroad or which it was, you'll remember. But it was all about Bigness, and it reads like today. Right now, this very day, every problem we have today in that time period reads like it does today. What was that?
It was probably the insurance scandal because the headlines there were so similar. CEOs using company money to buy Persian rugs. One of them paid for a big coming out costume party for his niece out of corporate funds. the same sort of headlines, just with different names that we have today. And New England policyholders in these big three companies were very upset. They wanted to know if for many people in those days, an insurance policy was their chief investment. The stock market had not become what it is today. So if you were, let's say, a doctor or a lawyer around 1904, 1905, your big investment, aside from, say, the purchase of a house, would have been an insurance policy which would have provided for your family if you died, or, because these were whole life policies, would have been your retirement, if you lived long enough. And they were extremely worried about the value of these investments, so they hired Brandise to look into this for them. About this same time, Charles Evans Hughes is conducting public investigations in New York, he's a lawyer at that time, into the insurance thing, and he's coming up with one scandal after another that's just like today.
Put him in context, by the way.
Hughes was a lawyer in New York. He eventually became governor of New York. He was appointed to the Supreme Court by Taft, resigned, later became Secretary of State, and then was named Chief Justice by Hoover. And Brandise thought the world of him. They didn't agree on everything, jurisprudentially. But Brandise was an admirer of his, thought that Hughes's investigation into the insurance industry was exactly the way he would have done it. And he liked the way Hughes ran the conference. He thought Hughes was the best Chief Justice he had ever met.
In the context of the insurance business back there, I wrote down that you said he had a strong aversion to the curse of bigness. But what impact did he have on it, and what the whole business of becoming a consumer's lawyer?
In the chapter on which I call A Perfect Reform, what I tried to do is show Brandise sort of the epitome of what made him such an effective reformer. He's opposed to bigness. He's opposed to bigness in business. He's opposed to bigness in government. He always says man is a we thing and has limited abilities. And while he recognized that in modern society you had to have delegation, you had to have, one person couldn't do everything, the idea of a factory that hired 10,000 people, he said no one can have any idea of what their business is when it gets to be that big. That there's an inefficiency of bigness. He opposed much of the New Deal personally, not as a justice, but personally because he was opposed to big government. Labor had a very mixed reaction to him. On the one hand, he was a strong proponent of labor's right to organize and bargain collectively. On the other hand, he wanted to put limits on unions so that they would be responsible. And this, of course, was anathema to people like Samuel Gompers and others.
And who was Samuel Gompers?
He was the head of the American Federation of Labor during this time, and he and Brandise debated on this. But when it came to the confirmation hearings in 1916, labor lined up completely in back of Brandise because they trusted him. Even if they disagreed with some of his things, they trusted him.
But speaking of those hearings, it took 6 months to get him approved. Why?
4 months, yeah. He was a radical. There's no question about it that as far as conservatives were concerned, this was a man who had attacked J.P. Morgan, had discovered that the Taft presidency was a big scandal regarding conservation and Alaskan resources, that the president had lied about what he had done. This is a man who had developed the Brandise brief to support labor legislation, which conservatives found anathema. This was a man who had attacked banking practices as then practiced, and who had attacked the courts as being not in touch with current reality. By any standard, Brandise was a radical. He wasn't an IWW type of radical, but as far as the conservatives were concerned, he was far worse because he was educated, he was trained, and he was effective. If you could ignore the wobblies, the real radicals over on the left, you couldn't ignore Brandise.
47-22 was the final vote?
Yes.
And the 22 who voted against him, what party were they in?
Almost all Republicans. Just about completely Republicans at that point. Only 3 Republicans voted for him.
If he were here today and on the bench, on the Supreme Court bench, who would be on his side? Who would like him and who would not like him?
That's a hard question. If you want to take today's court, a lot of what he preached is accepted by all members of the court. A lot of what his dissents were in the 1920s and 30s have been accepted. Let me give you one example. We think of Antonin Scalia as a conservative, a very conservative justice. A few years ago, Scalia wrote what was in essence a Brandisian opinion. The case came about this way. Police in a California town were cruising up and down with an electronic device in their car to pick up heat sensors. And their idea was if they could pick up a heat signature, they would know who was growing marijuana because you have to have all that light which generates heat. Well, they picked up a heat signature from this house. They then went and got a warrant, went in, and sure enough, the guy was growing marijuana, but they never had a warrant to use the thermal sensor to look essentially into the house. And he's convicted in the lower courts, and he comes up, and Scalia writes what is a Brandisian opinion on privacy, saying you can't just look into somebody's house because you have the technology to do so. You need to have a warrant. And this is essentially what Brandise wrote in the Olmsted opinion regarding wiretapping. You can't just because you're outside the house doesn't mean you can take those alligator clips and listen in on the telephone conversations. His jurisprudence of free speech has been adopted by conservatives as well as liberals. His notion of judicial restraint to allow legislature to do what they're permitted to do is paid lip service by everybody, not always carried out, but it's paid lip service by left, right, and middle. So it'd be very hard to say where he would be, but I think to take one specific case, for instance, the Ledbetter case, in which the conservative majority took a very wooden, literal view of the law and said that unless Ledbetter could prove, filed a complaint within 90 days of the very first discrimination, she had no cause of action, is insane. She didn't know that she was being discriminated against for 20 some odd years. Brandise certainly would have been with Ruth Bader Ginsburg and the moderates on that in trying to inject a sense of common sense into the opinion.
A couple other things you say in the book is that he wasn't for initially women's suffrage.
No, he wasn't.
And that he wasn't active in the civil rights movement of those days.
He was not initially for women's suffrage, in fact spoke against it, but then he married and had 2 daughters. And he also associated with some very, very intelligent women. Florence Kelley of the National Consumers League, his sister-in-law Goldmark, he knew Jane Addams. He knew some other, Mary O'Reilly in Boston. And gradually he came to the conclusion that his argument was fallacious, and he comes out, and especially his wife. His wife was a strong supporter of women's suffrage, and the very shy Alice actually went on stage to speak for it, and that may have been the final thing that brought him over. In terms of civil rights movement, as a historian, you have to be very careful to distinguish between what was going on in the 1910s, 20s, and 30s in terms of a civil rights movement and what happened later. The NAACP at that time was a very small group. Felix Frankfurter was involved in it. And the jurisprudence of the time was very different. Segregation was seen as state action. And even the NAACP didn't know how you would attack state action in federal court. You have to recall that not until the 1950s, really, do we begin to get a Supreme Court that allows federal review of state action in a number of areas. Now, interestingly, although Brandise has been charged, I think the main charge is he wasn't a champion of the African American. He championed all these other groups. Why didn't he champion them as well? Which is a strange argument. But in all the cases that did come up before the Supreme Court that the NAACP brought, and there were only a handful during the time he was on the bench, in every single one of them, he supports the NAACP to strike down some form of prejudicial legislation. So in the book I argue it's not, yes, it would have been wonderful had he also done that, but he didn't. And that's understandable.
What do you think you would have thought of him as a personal friend, or would you have liked him, do you think?
If I were a close friend, I would have. If I were just a casual acquaintance, I would have thought of him as cold, hard, all business, no nonsense. But his good friends, people like Norman Hapgood, thought the world of him. Robert La Follette. He didn't have a lot of close friends. He was a man who made use of every minute of his time. Although he took 1 month off every year, he once wrote that he could do 12 months worth of work in 11, but not in 12. So at a relatively early stage in his career, when he can afford it, he started taking the month of August off. And he took long weekends and others. He believed that the worst thing a person could do was to be tired, because you made mistakes when you were tired. And he swore that after an early experience where a lawyer whom he greatly respected had made a mistake because he was tired, he swore that would never happen to him.
One of the things I saw reference to in your book and other places, and I think you might have even done a book on this, is the 1914 book that he did, Other People's Money and How the Bankers Use It.
I've edited that book. Or not edit, I wrote a new introduction. You don't edit it, but yeah, I've written an introduction to that book. And last fall I had an op-ed piece in the New York Times in which I said everything he says in that book regarding bankers, what they do, how they use other people's money, is still true today. And that the best thing we could do is learn from it.
Well, let me ask you this. I went into, because I kept reading about it, I went into Google, typed in Louis Brandeis and Other People's Money and How the Bankers Use It, and you can read the whole thing right there on the internet. How do you think he'd feel about that, based on the fact that he was involved in copyright and all that, privacy, and if it's free?
I think he would have very mixed reactions. On the one hand, it's a wonderful source of information to all people. And like most progressives, he believed that you could never know enough. And that one of his arguments for free speech is that an educated citizenry is absolutely essential in a democracy. And that we don't censor speech so that people can hear all sides of an argument. I think he would have thought the fact that anybody could sit down in front of their computer and get all that information would have been wonderful. On the other hand, the fact that it intrudes in so much of our daily life. And you walk down the street now and you see people talking to themselves. Well, of course, they've got the earplugs in. It wasn't long ago they would have arrested people who were seen walking down the streets talking to themselves. Cell phones are everywhere. He didn't even use a phone later in his life. He thought it was an intrusion into his privacy. So I'm sure he would have objected to cell phones and their ubiquitousness today. He would have had mixed reactions.
Where did he live here in Washington?
He lived up on Florida Street. Or I'm sorry, on California Street.
So not within walking distance?
Yeah, he used to walk down.
Did he really?
Yeah.
And I want to make sure our audience, those that are interested, is Other People's Money and How the Bankers Use It, 1914. You can find it. I also want to show you a clip of his grandson, Frank Gilbert, who lives here in Washington,
right,
who we talked to in conjunction with our special on the Supreme Court. Do you know him?
I do. I've known Frank for a number of years.
He's talking about the Supreme Court building back in 1935. He didn't move into it, but let's listen to what he has to say.
He had the law books spread out on the floor of his bedroom office, which was not a large room, and that served him very fine, in a very fine fashion, and so he saw no need for this marble palace. He didn't want to be any part of it, although he had very good relations with his fellow justices. They all used the building. One of grandfather's law clerks told me many years later that one of his fellow justices raised some objection about the building, and rather uncharacteristically, grandfather turned to the law clerk and said, well, he voted for it.
The modern Supreme Court building was Taft's initiative. Prior to the new building, they met in the old Senate chamber in the basement of the Capitol. It was cramped. There was no room for private offices. The justices put on their robes and then had to walk down the hall to the courtroom. And Taft thought that as one of the three main branches of the government, the Supreme Court ought to have a building that was comparable to the Capitol or the White House, and he pushed it through. Brandise always liked the old courtroom. He liked the idea that the court was a small body, one man each with one clerk doing the business of the government. He liked that. And when the new building opened, he refused to move into it. His wife was curious, so one time, in fact, they kept his chambers open to the public so that when they were running tours through the building, this is where they could show what a justice's chambers looked like, because his was unoccupied. And one time Alice Brandise wanted to see it, so she sort of snuck down there. And when she came out, somebody asked her that they have ice water and shower baths, and my husband doesn't use either one of them. I mean, she thought these were much too elaborate. He did, and he never moved into his chambers during the time that the building opened until he retired.
Our producer for our Supreme Court series, Mark Farkas, was worried that people thought that Louis Brandeis didn't bathe, and I guess he liked the bathtub instead of the shower. Another thing that was mentioned by Frank Gilbert was the clerks, and if you get on the list of clerks, you'll notice that all of the clerks for Louis Brandeis came from Harvard.
That's right.
Unlike any other justice. I mean, nobody else had only Harvard clerks. What was the point?
No, Holmes did.
Oh, did he?
Holmes had his from Harvard, too, because he got them from the same source, Felix Frankfurter, and before that from Professor Gray. This was not unusual. I mean, justices, William O. Douglas, for instance, only took his clerks from the Ninth Circuit. So it's not unusual for justices to say, I only want clerks from here. Now, of course, they have 3 or 4 apiece. Also, in those days, sometimes clerks would stay more than 1 year. For instance, Harlan Stone had a clerk that stayed with him for, I think, 7 or 8 years. So it was a different arrangement than we have now, where they all leave after 1 year. Brandise had 2 clerks that stayed 2 years each. One of them was Dean Atchison. And then the rest of them only stayed for a year. And Frankfurter chose them. 1 or 2 of them came down and met with Brandise first, but for the most part, they showed up in August, where the former clerk would essentially teach them the ropes, and then they would be there.
If today a Supreme Court justice was paying somebody like Frankfurter at Harvard to do a project of any kind, and that professor was providing this Supreme Court justice with all their clerks, do you think this would work today?
We're in a much different environment after Abe Fortas, the Fortas scandals of the 1960s. I met with a member of the Judicial Conference office that handles judicial ethics, and I sent him some chapters from the book. And I wanted to know, is there anything unethical about what Brandise was doing, either by the standards of his time or our time? And he said that there was nothing unethical or illegal, but that because of the closer scrutiny of what justices do since the Fortas scandal, that Brandise probably would not have done some of these things. Now, asking a particular professor to provide clerks, there'd be no problem with that. Providing a professor with a stipend to engage in reform activity today probably would not fly.
I want to go back to Frank Gilbert again. Who was his mother? Do you know?
Susan. Susan was his mother.
And do you know him?
Yes.
And what's he do in Washington?
He works for the Historic Trust, National Historic Trust Foundation.
Well, this second clip I want to run is still today mind-boggling. We've talked about this before on this program, but let's watch it and you can explain it.
Sure.
When it came to his resignation from the Supreme Court in 1939, as is customary, the Chief Justice wrote a letter to the retiring justice to praise him and indicate how much the court would miss him. And after Chief Justice Hughes drafted this letter, the senior associate justice, who was Justice McReynolds, declined to sign the letter. The other justices immediately signed the letter, which was sent off to grandfather, and it stands to this day as an indication of how Justice McReynolds felt about grandfather. But to Chief Justice Hughes's credit, he didn't need that signature. He wanted it to stand with all the other justices, indicating their respect and affection for my grandfather.
Weren't both Justice Brandise and Justice McReynolds from Kentucky?
No, I'm not sure about McReynolds, but I think he may have been.
But it was just odd. What in the world? What was the thinking back then that and explain how far McReynolds would go not to be around Justice Brandeis?
Well, first of all, you have to go back before they both went on the court. McReynolds was Wilson's Attorney General, and apparently worked very closely with Brandise in 1913 and 1914 to draft legislation. We have a number of letters from Brandise saying, I met with McReynolds today. He and I spent several hours. He once writes to his wife, McReynolds is besieged with office seekers. I'm so glad I didn't get that job. He had been talked about as a possible member of Wilson's cabinet. And at least up until that time, their relations seemed relatively cordial. But once McReynolds went on the bench, his anti-Semitism just flowed completely, just ran forth, gushed out. And during the time that Brandise was on the bench, McReynolds wouldn't talk to him unless absolutely necessary. During the conference, the weekly conference, when they went over cases, McReynolds would, when Brandise was talking, would sometimes go to a couch on the side and read his mail, or sometimes even leave the room until the Jew was finished. There are a couple of years we do not have official portraits of the court because McReynolds would not pose with Brandise. And after Benjamin Cardoza came on in 1932, McReynolds was horrified to have two Jews on the court.
Brandise was the first Jew on the court.
Yes.
Did anybody ever ask McReynolds why he felt this way?
Not that I know of. And
we've got the memoir. It was done
by his clerk.
By the clerk.
Right, but it doesn't really say why he felt this way. I mean, it was just prejudice, pure and simple, as far as I can tell.
Did Justice Brandise ever talk about this?
He ignores McReynolds for the most part. He doesn't have a great deal of respect for him, not because of his prejudice, but because McReynolds was a poor justice. Brandeis and Hughes and Taft were all appalled at how sloppily McReynolds did his work on the court. And there's an interesting letter, though, that one time, for some reason or another, in a relatively minor case, both Brandise and McReynolds were in dissent with the majority. Excuse me. And because Brandise was working on a larger dissent, he asked Reynolds if he would write, a brief dissenting opinion. And he comes home and he says, McReynolds was so happy that I asked him to do that. So, I mean, it's a strange relationship. There are some places where if you look at the notes in Brandeis's court papers, for example, where McReynolds writes back just like the others do on the returns, doesn't say anything nasty, sometimes makes a suggestion. It's like business as usual. And then there are other times when, you get these stories. McReynolds was a very strange person.
In the end, why did Justice Brandise spend so much time and money at the University of Louisville at their law school, and throw into that mix Brandeis University and what he had to do with that, if anything? I know it came on but 48 or something like that.
Well, he had nothing to do with Brandeis other than that his name was taken. In fact, one of his daughters thought that if he were alive, he never would have allowed a university to be named after him. He, of course, grew up in Louisville, but his interest begins to grow in the 1920s when Harvard Law School expands under Dean Roscoe Pound, and Brandise is very much opposed. Now, Brandise had been a generous contributor to Harvard Law. He had been one of the founders of the Harvard Law School Alumni Association. He was its longtime secretary. He was on the Board of Visitors. But Pound in the 1920s feels that Harvard is still a 19th century law school, and that in order to meet the needs of the 20th century, they're going to have to expand the faculty. And in order to expand the faculty, they're going to have to expand the student base. And this is going to mean larger classrooms, at least in the general courses, the first-year contracts towards them. And Brandise is dead set against it. So one reason he turns to Louisville is, part of it is the curse of bigness. Harvard was now too big. And what he wanted was not one big Harvard, but a lot of little Harvards, as he put it. And the University of Louisville was to be his experiment. He and his brother in Louisville, Alfred, took the lead in raising money. Brandise arranged for his very extensive library to be given to the University of Louisville. He helped bring in a dynamic dean of the law school. He gave a lot of money, but in small chunks. He was opposed to this idea of big dollar investments, and he's constantly advising them, don't go after the big dollars. Go after a lot of little dollars, because that way you get people involved, interested. I think he would have applauded Obama's use of the internet to raise a lot of $25 contributions rather than trying to get somebody to give $250,000. He wanted the local people involved in the development of the University of Louisville. And today, if you ask the dean at the University of Louisville Law School, they consider themselves a second-tier law school, but one of the best of the second-tier law schools. And they are also a law school that has a required public service component to their curriculum.
And how much was he responsible for the pro bono publico section of these of some law firms today?
Well, he almost invents pro bono when he gets started. He writes, he tells his fiancée that Alice, when he's courting her, that he hopes that eventually he will do well enough in his law practice to be able to give at least 1 hour a day to public service. Well, he does very well in his law practice. And a woman named Alice Lincoln, one of his clients, comes to him and asks him to represent her. She is a reformer, and she is appalled by the conditions of the Boston Hospital for the Insane, which is out on an island in Boston Harbor. Brandise goes out there. He says it was one of the worst days of his life. It was like going through a syphilitic ward, and you felt unclean when you left. So he represents her, and he tries to get the city to adopt better conditions, which they do, although by current standards, it wasn't that much better. When Mrs. Lincoln sends him a check, he gives it to a charity. And eventually he stops taking fees for public service work completely. When Edward Filene, who was one of his clients as well as a collaborator in several reforms, wanted to find out how much he was charging, he finally comes to Brandeis's office and says, look, you did all this work, how much is it going to cost? And Brandise said, it's going to cost nothing. This is my obligation to do this. Just as it's your obligation to be a good citizen, this is how I do it. And just as a collector would not, or a yachtsman would not enjoy being out on the sea if he were paid to do it, so I wouldn't enjoy doing this if I had to be paid. There was one point during his fight with the New Haven where he was putting in so much time that he felt it was unfair to his partners in the law firm, because he was the big rainmaker, that he actually paid his law firm $25,000 out of his pocket for work that they were doing to help him and other things. And as his partner, Ned McLennan, said, none of us would ever have even thought of suggesting this. It was just something we did with and for Brandise, but he was the one who insisted on it.
This is what book for you?
50-something that I've either edited or written.
This is 955 numbered pages. Who do you want to read this?
Well, everybody, but I would like people who are interested in public affairs to read it, not just the court, but in government. I would like young lawyers, people going to law school, to read it, to see how law can be used in the service of the public. I would like people who want a better society to read it, to see how it's not just that you have to have an ideal of what things ought to be, but you have to have a sense of how do you get there, how do you do something that's real. I would like judges to read it, to remind them of how law has to be wedded to reality. So there are a lot of people I would hope would read this.
Where are you from originally?
A place called Liberty in upstate New York. small town.
Where'd you get your undergraduate degrees?
At Columbia, and I have a PhD from Columbia and a JD from the University of Virginia.
What impact at age 40 and beyond did that law degree have on you?
It opened up a new teaching career for me, if you will. I have taught at different law schools. I've been a Fulbright down at the University of New South Wales in Sydney. But it allowed me to start writing about legal affairs, especially law and public policy. I've done books on affirmative action and the right to die and campaign finance. And it gave me the confidence that when I was writing about a legal issue that I really did understand it, whereas prior to going to law school, I would skirt around it because I always was not quite sure that I did understand. And many of the times I did, but I now have the confidence that if I wanted to write, and for the past 30 years, all I've written about really is about law and public affairs.
There have been 111 justices in history, and he was the 67th, I believe. Why? What is there one thing that you can point to that makes him one of the best known, and in many people's eyes, and we just have a minute or so, one of the 2 or 3 best in history?
I would say that his jurisprudence on free speech and privacy, if nothing else, would mark him as a great and influential justice. There was, of course, a lot more, but in a minute we can't go into it. But if there is one decision or 2 decisions that should be read, it would be his decisions in Olmsted and Whitney on privacy and free speech. They ring through the ages. They're still quoted extensively.
What's your favorite chapter in this book?
Getting started, when he's appointed to the court and how he developed the working habits he had and his relations with his clerks and everything. I don't know why I like that better than the others, but I do like it.
What's the one thing you didn't like about him?
That he burned so many of his papers that might have given us better insight into him, but considering that this was the man who developed the right to privacy, one can sort of understand that.
Melvin Urofsky has been our guest, and he is the author of Louis D. Brandise, A Life. Thank you very much.
You're welcome. It's been a pleasure being here.
For a DVD copy of this program, call 1-877-662-7726. For free transcripts or to give us your comments about this program, visit us at qna.org. Q&A programs are also available as C-SPAN podcasts.